On Monday, in what is expected to be a landmark court case, the Embrace Project will be challenging the definition of sexual offences. The organisation argues that the law is indirectly discriminatory and that the inclusion of consent as a requirement for many sexual offences creates a disproportionate burden on the victims of sexual offences, the majority of whom are women. For more on this, I'm joined by Leanne, Germanos, Manuel from the Embrace Project. Leanne, thanks for your time. Let's start off with you unpacking what I just said in that opening intro, because it seems a little bit more complicated. Well, it might be less complicated than I put it across. If you would just break it down for us.
Hi, Hugo. Thanks so much for having me. So the Embrace Project is basically taking the Minister of Justice to court to change a few of the sexual offences provisions in the Sexual Offences Act. What we are asking for is actually to make the law a lot more objective and to move it away from sort of the subjective stance that it currently takes in favour of an accused person. We're not wanting to remove the element of consent when it comes to sexual offences. That's actually an argument that's been put forward by an intervening applicant, who is CALS. What we're asking for actually is something a lot more simple, a lot more reasonable, and quite frankly, constitutional, as we believe that the current provisions are not constitutional. To sort of break it down and make it a lot more simple.
Please.
If I were to take the example of rape, which is one of the sexual offences in the Sexual Offences Act that we are targeting. For rape, there are 4 elements that need to be proven by the state before a conviction is obtained. The first element is unlawfulness. The second element is intent. The third element is you have to prove an absence of consent. And the fourth element is that you have to prove that there was sexual penetration. That's for rape. There are 3 elements that are fairly simple to prove if the state has a strong case. And those elements are unlawfulness, the absence of consent, because you can prove that using the complainant, and also then obviously an act of sexual penetration, which is usually done with medical tests, usually after a rape. The most difficult one for the state to prove, and that is also why we have such poor conviction rates when it comes to rape and just generally sexual offences, is intent. Now, the intent requirement is positioned as such that it requires the state to prove that a perpetrator subjectively intended to rape a victim. So in other words, in their mind, they intended to actually, they in other words knew that the victim didn't consent and they were happy to go ahead and commit an act of sexual penetration. The reason that is so difficult to prove is because it's very hard to actually get into the mind of an accused person. And if you have a defense that says, no, I, as the accused, actually genuinely thought that there was consent, and the reason for that is because there was no objection in any form, whether it was physical or verbal. I didn't hear any objection from the complainant. So in my mind, I had consent.
Leanne?
And that has actually been proven. We have sort of expert amici, so these are friends of the court, that have entered our case as well, and are actually telling the court, listen, the most common response for complainants, for victims and survivors of rape in the act of the sexual assault is to freeze up. It is very uncommon for them to actually object. So you can imagine then how hard it is for the state to prove that an accused person subjectively intended to commit a sexual offence.
If we look at if we look at gender-based violence cases, and I'd imagine that a huge or a fair number of those are rape cases. If this law is altered, how many of those cases would come down, or how many cases would result in conviction in your mind?
Well, what I'm hoping for to begin with is that a number of cases will actually be brought to court to begin with, because I think what we forget is that, we have, I think the last statistics were 48,000 reported cases of rape to the police, and there were as little as 500 or so sexual offences convictions, only a part of which were rape. So you can imagine how few of those reported cases of rape even saw the inside of a courtroom to begin with. So my hope is that with a change in the law, because what we're asking for is to make the law more objective, to say, instead of focusing on the subjective intent of an accused person, can we please focus on the facts and the circumstantial evidence surrounding this rape? Could a reasonable person have come to the conclusion that, consent was given? And that's not the question currently asked by the court, because that's not what the law allows. The law asks that the court look at the accused person and not the circumstances surrounding it. So I'm hoping with a change in the law that, first of all, we'll have a few more rape and sexual offences see the inside of a courtroom, actually go to trial. And then secondly, a much higher conviction rate. So you're looking at, almost hopefully like 100 or as close to 100% as possible. Currently with the law and, the very low number of cases that even see trial or see, at the inside of a courtroom, you have a conviction rate of, I think, in the 80s, in the 80% or the 90%, and we're talking tiny 500 convictions throughout the country for a 1-year period,
Leanne,
which is really abysmal.
I don't imagine that this is going to be a walk in the park for you, and that's because there is obviously some opposition. Now, what are the main arguments presented by the Minister of Justice in opposing this constitutional challenge?
Yeah, so the Minister of Justice's main argument against our application, I must state here that we were actually surprised that we received opposition. The Minister of Justice is saying that if we change the test from a subjective test to an objective test, we would be infringing upon an accused person's fair trial rights. And the reason that the minister argues this is he says that what we would be doing is we would be placing the burden of proof on the accused person when it should be on the state to prove that the accused is guilty. We would be placing the burden of proof on the accused person because what we're asking for is that the accused person should be required to take all reasonable steps to ascertain whether or not consent was given. And the minister has a problem with that. He says that's not fair on the accused.
So what happens?
In addition...
Sorry, I have to ask this. If we look at what's happening across the globe, or in more forward thinking, if you will, for want of a better description, judicial systems across the globe, what is the standard practice there, and how does it differ from what we currently have in South Africa and what it is that we are looking towards?
So there are a few jurisdictions who've already actually put through what we're asking for. They've already changed their laws. That includes England, Australia, New Zealand, Canada. They've changed their laws to take away the subjective intent element and replace it with an objective test, a reasonableness test that requires an accused person to take all reasonable steps to obtain whether or not consent was given. So those jurisdictions have already done that. And we've given those as examples in our application. The minister, in response, has said, no, we can't use those jurisdictions as examples because they're not comparable to South Africa. They have a homogenous society, whereas we have a heterogeneous society, which we find quite shocking for the minister to say that Canadian, English, people from New Zealand, that their communities are homogenous, that they're the same race, same ethnicity, same religion, which is, just blatantly and factually untrue. And that is also one of the arguments that the minister puts forward as, saying, our jurisdiction can't take on the example of those jurisdictions because we're just different.
Now, when we talk about the conviction rates, which you've said are very, very low, a lot lower than you'd like them to be, how much this points to the capacity of those that are the lawyers, I'd like to suggest, how much speaks to their capacity or lack thereof to convict the accused?
So, we're talking about state prosecutors, right, and the capacity of the NPA to prosecute cases that come across their desks. They work very closely also with the police, and they're really dependent on the police for evidence and the evidence that they need to be able to take a matter to trial. I think it's no secret that the state and the state machinery, particularly the criminal justice system and institutions, that they are very much sort of overcapacitated with very little human resources. So I think obviously that plays quite a big role. I think state prosecutors are inundated with cases that come across their desks. And that's also why they're so selective in the cases that they decide to put their time and energy in and take to trial. You know, if you're going to do that, because it requires a lot to take a matter to trial. And if you're going to do that, you want to be sure that you're going to win. And I think that's also like a big deterrent for state prosecutors to go ahead with every rape case that comes across their desk if they don't think that the court is going to find in their favor or find a conviction.
Now, you talk about winning, so the 22nd, which is a couple of days away, is a big day for you. How confident are you of your victory?
So I honestly believe that what we're asking for is it's so reasonable. And I do believe, in our case, I believe that the sexual offences that we're targeting, the provisions in the Sexual Offences Act, are unconstitutional. They are outdated. They are unjustified. And I genuinely believe that the court will find in our favour, more so because I believe that the arguments put forward by the minister are, really rebuttable. So I do believe that the court will find in our favour, but I'm also very aware of the fact that this is only the beginning of the journey. Once we get heard on the 22nd on Monday, finally after 2 years already, we still have to wait for judgment. And after that, see what happens. If it's a judgment in our favour, we'll have to see what the minister does. If it's also a judgment that's in our favour but not in CALS's favour because their relief is very different to ours, we would have to see whether or not they would then want to take the matter on appeal and also prolong, the ending of this matter, which has to end up in the Constitutional Court because it's a constitutional challenge. Whether or not the judgment by the High Court is taken on appeal, it has to end up in the Constitutional Court for it to certify that the provisions we've said are unconstitutional and that the High Court will have confirmed are unconstitutional. It's then still for the Constitutional Court to basically rubber stamp that and tell Parliament or the legislature what it is that it has to do to remedy the defects that we've pointed out. So that'll still be a few years.